So good evening, everyone. Thanks again for coming. Hope you found something good to eat and drink. My name is Heidi Thole. I am an intellectual property shareholder at Reinhart, and I am so excited to have you all here for the launch and filming of our first episode for a brand new podcast, the RIPL Effect. Before diving in, I just wanted to say thank you to our friends at Broken Bat for hosting us, and a huge thank you to our marketing team, especially Kate, who did such a great job of putting this event together. And lastly, I wanted to say thank you to all of you for coming. Today we will be going over some basics about trademarks and specifically kind of issues that we see come up commonly in the brewing, distilling, and food and beverage industries. As you can see, we like to keep things a little casual and conversational, so if you have a question at any time, please feel free to ask. Otherwise, we will have questions at the end. So as I mentioned, this is a brand new podcast that I'm working on. I had previously worked on a legal podcast at Reinhart, mostly because one of my colleagues and I talked a lot about the law, probably more than our families wanted to, and case updates, so we wanted to give them a break and record something else. But the impetus for this new podcast that I'm doing was a little bit different. I was wanting to revamp and kind of do a new spin on a podcast, and I was working with Kate and Andy, and we were kind of thinking of different ideas. And Andy said, "Oh, I have this really good idea for a beer name, IPL." And I was like, well, beer, who doesn't love that? Let's start with that. So actually we brewed these cans of IPL for you this evening. I love a good pun, so this one is clearly a reference to an IPA, and also IP refers to intellectual property, which is the type of law that I practice. So intellectual property covers a bunch of different things, including copyright, trademark, name, image, likeness, advertising, sponsorships, whole gamut of things. But the thing I really love about it is that branding is essentially storytelling. Every client that we have, whether they're a person, a small business, a business that's been around for 100 years or internationally, they all have messages they want to send to their clients about their products, a message or an image that they want to communicate. And branding is a big part of how they do that. So with this new podcast, the RIPL Effect, it is, not surprisingly, because I do love acronyms as well, RIPL Effect stands for Reinhart IP Law, and the whole name, the rebrand, is RIPL Effect. So we will have monthly episodes rolled out, and we'll try and keep them to about 5 to 10 minutes apiece. Unfortunately, I can't promise beer and food for all of the episodes, but we will try to keep the tone light and conversational while also tackling new cases or new updates in the law, and specifically leaving you with key takeaways. My hope and mission for the podcast is that watching an episode will be like a small stone. There won't be any heavy lifting. Actually, hoping you'll enjoy me on this journey of recording this podcast. But like a small stone you drop in the water, it'll ripple out and hopefully have useful implications in your day-to-day life or in business. So today for our first episode, I thought we would kind of start with, I was going to say the basics, but trademarks can quickly become anything but basic, but it is kind of the foundation. And we see them so much every day. I had read an article recently that said when you go grocery shopping, you see anywhere between 5,000 and 10,000 trademarks. And with use of social media and the internet, it's probably more than that. So you're literally seeing thousands and thousands of trademarks a day. And they can be really integral when a customer is deciding, they're running through the grocery store, what beer do I pick up? Being able to recognize a certain logo or can style might make the difference for them between what they choose based on their past experience and with that brand. So I wanted to start out by discussing kind of basically what a trademark is. And a trademark at its core is anything that can serve as a symbol of the source of goods or services. So that can be pretty broad. There are lots of trademarks. As I mentioned, you see them every day, and there are different types of trademarks that I wanted to mention. Not to play favorites, I was going to use some macro brewing examples. So for example, you might see house marks. So those are marks that are used across all products and services. For those, you might think of Miller, Pabst, Guinness, Heineken, similar things. You might also see trademarks that are specific to a family of products or a single product. Examples of these might be High Life, Blue Ribbon, or Harp. And then there's also the logo. So as you see, it quickly builds. So you might have one product with multiple trademarks on it at one time. Some of the logo examples that I came up with are the harp you would see on a bottle of Guinness, I think it's a girl sitting on the moon that we all know so well from the old Miller High Life signs, or that blue ribbon on Pabst. So those are some traditional ones, kind of building out from there. Slogans can also function as trademarks. A couple of examples are Beer Built Right and America's Fine Light Beer. Going even a little more broad than that, and where it kind of gets a little crazy, is things like color scheme and even product packaging can serve as a trademark. For example, the shape of an old-fashioned Coca-Cola bottle functions as a trademark because over time consumers have learned to associate that particular bottle with products provided by Coca-Cola. And one of the more interesting ones I found in preparing for this presentation, I knew about jingles, and I'm sure you all have like a jingle stuck in your head from watching TV or listening to the radio, but I did find a trademark registration for beer for the sound of birds cawing. Didn't know that that was a thing, but there's a company that uses it frequently in their ads and has registered that. So that's a pretty wide array of things that can function as a trademark, but there are a couple of caveats I'd like to kind of carve out there. Not everything can be a trademark. It has to serve that basic purpose of indicating the source of the goods or services. So for example, if something's informational, if it says only American-grown hops, that probably can't function as a trademark because it's telling you something specific about the product rather than telling you about the source of the product. Ornamental material may also fail to function as a trademark. We see that a lot with t-shirts, where there's a really cool design on a shirt and people buy the shirt because the design is really cool, but they buy it because it's aesthetically pleasing rather than because the design tells you something about who makes the shirt or who authorizes the shirt. And then finally, matter that is generic cannot function as trademarks. And usually we don't run into that too often with brewing, distilling, and food and beverage clients. So good job, guys. But we do with some other clients. One example I can think of is recently in the packaged goods aisle, there was a fish fry product, so a product to kind of make breaded fish at home, and they tried to trademark fish fry, and the court ended up finding that that was generic because it described the product. People often think about trademarks as kind of falling along a continuum from really strong to really weak. That's how I think about it too, but I always have to make things difficult. But I think of it almost as a teeter-totter. So you have really strong and then really weak, and then in the middle you have suggestive and descriptive. And whether or not something is suggestive or descriptive can make the difference between whether or not it's registrable and protectable, or it's going to be difficult for you to register or difficult to protect it. So kind of where the fulcrum is on that continuum is between something that's suggestive and something that's descriptive. So an example of something that is descriptive would be, for example, juicy IPA, because it describes what the IPA is. But it can become really confusing really quickly whether or not something is suggestive or whether it's descriptive. And this is actually something that the Trademark Office and courts run into not infrequently. So I just wanted to do kind of an exercise regarding kind of descriptive versus suggestive. So suggestive means it takes you just a second to kind of put together the connection between the trademark and the product. So I would say that juicy IPA is descriptive and therefore not suggestive. But what about the term, what about milk stout? If I could get maybe a show of hands, how many people think that's descriptive? Anybody think it's suggestive? Well, it is confusing. I saw a lot of hands for it being descriptive, and a lot of this is on a case-by-case basis that you can kind of find out by looking at the Trademark Office records. And so for those of you who said descriptive, you're right. I had another one to follow up with. How about milkshake stout? Show of hands for descriptive. And see, that's actually a really good question, because I knew there was a milk stout, and I was doing this search, and I saw a milkshake stout, and I saw, I don't know what that is, but it sounds really good. And so the question, well, the answer the Trademark Office came up with, and they are not the end-all, be-all, and everything, but they said that it was descriptive, but it could potentially acquire distinctiveness over time. And so essentially, it's not so common that, you know, there's no chance and people are just gonna look at it and say, oh, that's describing the product. They kind of put it on this thing called the supplemental register, which is kind of the second register for trademarks, where marks that could potentially become source identifiers are registered. So that's another thing to kind of take away, is that trademarks can kind of move along that scale over time. Thankfully, things that start out a little more descriptive, for companies that put in time and money, effort into creating brand recognition, that can slide from descriptive to suggestive. However, the reverse can be a little bit true. If you start out with a mark that's, you know, maybe not coined or, you know, arbitrary, and it's a little more suggestive, over time, if more people see it and say, hey, milkshake stout sounds like a really good thing, let's start using it, then it can become more descriptive over time. And this is one of the things that makes trademarks not as easy as we would like them to be, is that it is the test for trademarks is based on the average consumer. And because consumers in the market change, you know, what is descriptive today might not have been descriptive 20 years ago, and vice versa. And we kind of see that when we are trying to do trademark clearance searches. But there are a couple of situations that we see kind of common that fall into the descriptive category that you wouldn't necessarily maybe think of, so I just kind of wanted to quickly mention those. Some common types of marks that might be initially descriptive are last names. The Trademark Office doesn't register last names unless you can show that there's acquired distinctiveness. Now, I'm saying that realizing I gave you examples of house marks that included Miller, Pabst, Guinness, and Heineken. So I'm aware of that, and actually for those, the applicants, when they did try to register the marks with the trademark office, they did have to make a claim of acquired distinctiveness and have to show evidence that they have gained consumer recognition over time. That can also be helpful if you're a smaller business, because trademark law kind of tries to protect your right to use your own last name unless someone shows that they've used it for so long and so exclusively that the only connection people are going to make are between that particular source and those goods. Another kind of common situation where marks have been found to be descriptive is when they consist primarily or entirely of geographic terms. So I'm trying to think. My example, this kind of combines with the next one, but Milwaukee's best. Again, that's another one where it might start out as descriptive. It started out more descriptive and then over time gained that consumer recognition. And then a lot of people want to highlight the excellent nature of their products, which is not uncommon. So words like best, premier, platinum, the trademark office kind of looks at those as laudatory or kind of puffery or kind of suggesting that you've got the best product. So that's if you would submit an application for a mark that has a laudatory term, you may get an objection that is descriptive. And so I kind of talked about kind of our continuum of trademarks and kind of this big difference between suggestive marks and merely descriptive marks. And that comes to play in both registration and enforcement. It really comes into play in federal registration. As I mentioned, if something is merely descriptive or the trademark office and the examining attorney determine that they're merely descriptive, then it's not eligible for registration on the principal register. And you might be asking, why federal registration? What difference does that make? It can be very helpful. A federal registration has a bunch of presumptions that come along with it. That includes the presumption that you own the trademark, presumption that it's valid, and that validity includes a presumption that it is not merely descriptive, and it also provides exclusive nationwide rights. The exclusive nationwide rights are particularly powerful for some of our clients that don't quite have national scale yet, but may or aspire to have national scale someday. So for example, if you primarily have your business located in Milwaukee or distribute in Wisconsin or the Midwest, but it would be harmful to have a competitor using this same name, in California or Georgia, somewhere that's geographically distinct. If you didn't have a registration, it could be really hard to stop them. But with a federal registration, because of that exclusive nationwide rights, it would be easier to kind of stop that use in a different market. And one more added benefit of federal registration is that after a time, it becomes incontestable, which means that people can no longer lodge certain objections to it. For example, they can't claim that they have priority, or that question of merely descriptiveness can no longer be challenged on those grounds. So finally, that pesky question kind of goes away. If you do not have a federal registration, there are still rights based on using a trademark. So in the US, trademark rights are use-based. So you still have trademark rights, but they're kind of limited to the zone of use. And so usually that means kind of the geographic region you're in. And that can be really great when you're starting out. Sometimes it can be a little bit harder to enforce. So while we certainly have had situations where we've been successful in enforcing common law rights, I see federal registration as kind of like rights plus, so it makes it easier to protect your trademark. So when thinking about a trademark to use, I'd be curious to hear from the audience, when you're thinking about potential logos or trademarks to use with your brands, what are some key considerations?
The name, the artwork style.
Yep.
You know, what image pieces that you're putting into it. Do you have to use the whole name? Can you use a piece of the name? Do you need to? I'll say it. Sure. Consider the name, the style of the artwork, the pieces that can go in. Can you do just a piece of the name? Does it have to be the whole name? Do you have some kind of slogan that goes on? If you have a logo or you have some sort of art, does a slogan go on it? Does it have to be registered separately? Is that you can do that together? It's giant confusing.
Absolutely. And when you say the name, are you thinking of using parts of like a name you already have used, or like a brand new name, a little bit of both?
Well, actually, okay, so I have Wizard Works Brewing. I would say that would be one thing to register.
Yep.
What about Wizard Works? Just that. Is that something separate that you would do, or is it included when you say Wizard Works Brewing?
So, yeah, that's a really good question. I would say that, so your trademark registration, so for example, if you were to do the whole thing, it protects the whole mark and anything that's confusingly similar. So for example, if someone else started using Wizard Works, you know, not the whole mark, but a shortened version of it, you would have a really good case that that is confusingly similar. They're using your mark, but they're just chopping off a piece of it.
Mm-hmm. What if it's not part of the same business stream? For example, Delta Airlines, yep. Delta Faucets. They're both called Delta, but there's no confusion based across. So what if somebody were to use Wizard Works and use it for gaming, which you could see actually happening?
Absolutely. Yeah, so that's one of the big considerations, is the similarity between the marks and the similarity between the goods and services. Delta is one that I use a lot of times when I'm trying to explain things. That one is a little easier because faucets and airplane flights are hopefully different enough that people wouldn't think they're offered by the same company. But as you mentioned, gaming gets a little bit more similar, and then it kind of starts to bring in other elements to the analysis. So the confusion analysis looks at similarity of the marks, similarities of the goods, and then looks at things like, you know, do the same customers buy the same goods and services? Is there going to be an overlap where a consumer might see your product and maybe at a gaming event or a competition and think, oh, they're somehow sponsored or affiliated with the event? So yeah, thank you very much for the example. So as you can see, it gets really complicated really quickly. Oh, and the other thing I wanted to add to that, gaming, beer, it gets trickier for things. We see a lot of times beer and wine, beer and distilled spirits, or even beer and, I think we've dealt with non-alcoholic beverages, orange juice. People make beer mimosas, you know, they can be mixed together. Are they similar? And so it's a lot to wade through. Usually it's kind of on a case-by-case basis. And so we'll kind of look at your mark, the other mark, and kind of the overlap. The way I kind of like to explain it for this particular area is it's crowded, and so people often ask me, is it a red light or a green light situation? And so sometimes I have red light situations. Very rarely, I'm happy to have green light situations, but they are few and far between. I would say a lot more of them are kind of like yellow light situations, which I liken to it being about 95 degrees in Wisconsin, and you're at an outdoor lazy river, and you don't know if you're gonna get a tube to even get in lazy river, or if you're even gonna get a spot in the lazy river. So it can be kind of confusing. So as we mentioned, things to consider so the test for assessing whether or not one mark infringes on another is called likelihood of confusion. Key takeaway is probably that it can be very fact dependent and get confusing kind of quickly. So the things that we mentioned, comparison of the marks, it's easier when you have a red light situation, exact same mark. That's usually pretty easy to say. It's kind of a big risk. But when we start dealing with situations where, there might be just one word shared and both marks have different words, or their logos and there's different artwork involved in both of them, that's where we come in and kind of do some of the searching. Because it's fact-based, it's good to kind of go in. Unfortunately, not everything can be risk-free, but at least if you go in kind of knowing what the background is, if there are other marks that share that same term, that kind of might give you a little more wiggle room to say, I can also coexist in this marketplace, looking at whether or not there are other marks that, one company owns the mark for good A, one owns a similar mark for good B, can kind of help you determine how the trademark office and the courts might see the similarity of those goods and services. And then another thing that we look at, which is kind of practical, is who owns those other marks? Are you going up against someone who files hundreds and hundreds of oppositions or complaints every year? If you've got a person who is very forceful about enforcing their rights, that might create a completely different situation. But I would say that in our experience, I'm happy to say that sometimes we can make coexistence agreements work. So I found some success with that when we've worked with breweries, distilleries, and other food and beverage clients, particularly where they're in distinct areas or they're not really going to overlap. So that is one way to kind of potentially deal with the risk. And then a couple of other considerations for trademarks is, how are you using the mark? Are you starting a brand new company, and is this going to be your key trademark that you're going to use everywhere? Is this a new product that is going to be one that you're using for a while, or is it a limited time release? Maybe, Oktoberfest is coming up. Are you going to have, a short-term Oktoberfest for this year? And then we also see trademark considerations when companies merge or acquire new assets. So those are just some key considerations. I know that's a lot. So I guess the takeaway from that is it can get confusing really quickly. Always happy to answer questions. Takeaway is that, comparison of the marks and the goods and services is probably going to be a main part of the analysis. And that is certainly something you can start with on your own. I know there are a lot of really great resources out there, like Google. Beer Advocate is one that we look at, when we're helping with searches. Even the trademark office's records are all available online. My bit of caution would be that conducting your own trademark search might be a little bit like trying to diagnose yourself with WebMD. I wouldn't recommend it, and part of that is kind of that analysis and looking at the case law, what's happened in the past, what can we determine, are there possibilities for coexistence agreements, do you potentially have priority over the other mark or any other leverage that you can use. And yeah, so great place to start, but we're always happy to help because the analysis can get really complicated really quickly. And so those are kind of my key takeaways for when you're thinking about trademarks. Oh, and just a quick side note, I know you had mentioned, all of the things that go into great packaging, not just the name, logo, artwork, all that kind of stuff. So because design is a really important part of packaging, I won't lie, sometimes I do buy beer because the packaging is really cool. So a lot of that stuff that is designed and subject to copyright protection, you can always, work with one of us or one of my colleagues at Reinhart to make sure that you own that. Copyright is usually owned by the person that creates it, unless they are an employee creating it within the scope of their employment, or it's prepared by an independent contractor and you have a written and executed agreement assigning the copyright to the work back to you. So that was just a little area sometimes where we see it's not always intuitive, so we like to make people aware of that. So with that, I would be happy to open it to questions. Yes?
I'm curious about when it comes to trademarking, or branding, I should say.
Sure.
When it comes to public figures, alive or dead. Like, what allows you to use somebody's image on a can, and do you end up also with not only like using a person's image, but also if the person has passed away, the estate part of it as well?
Yeah, that is a really good question. We actually just recently had a case about that. So for people that are alive, you definitely need their permission. There's actually a part of the Trademark Act that says you can't register the name, image, or likeness of a person, a living person, unless you have their permission. And if you have their permission, super easy. We can write up a little, I allow my name to be used, and that's pretty easy if they agree. For people who are deceased, it does depend on, you're right, in some cases the estate can still own trademark rights. I'm thinking, for example, the estate of Johnny Cash still is very big in what they do. Einstein actually gave all of his intellectual property rights, including rights to his likeness, to a university in order to create income to further scientific research. So actually, I never thought that Einstein would be, something, and I can't remember, it was something that rhymed with Einstein. It might have been Divine Einstein, something like that. But I hadn't thought that there would be residual rights, and then I kind of looked into it, and I had seen all of these applications that were rejected, and so in that case, they were very aggressive, and so that's kind of on a case-by-case basis, and so a little bit of research is necessary for those ones.
So you can't do your Caligula stout.
That one might be so far back, I feel like. I'm not exactly sure with the limitation, but I feel like Roman emperors you might be okay with.
Well, that brings up the question, how far back do we go? I mean, Mickey Mouse, the original Mickey Mouse Steamboat Willie just came into public domain. You could use that. You can't use later versions of it. How far back do we have to think about?
Sure. So I would say, actually that's really interesting because the copyright ran out on Steamboat Willie. Disney has started using that as a trademark on things, which is really interesting because copyrights have a definite life. Trademarks you can have as long as you're using them. So in that case, they kind of went around the copyright and started using it as a trademark. So in that case, that's what, about 100 years now? So I would say give us a call if it's anything more or closer than 150 years ago, but it's always good to double check.
I wanted to ask about enforcement, because you're talking a little about trademark enforcement. Once you have your trademark and somebody else might, so do you have to constantly be prowling everything out there in your industry to see if somebody's using your stuff? Because if you don't and somebody starts using it, how long can they use it before you can't enforce your trademark anymore? Because they say, oh, well, you've just neglected this.
Sure. So the good news about that is that enforcement is kind of based on what's practical for you and your business size and when you first became aware of the other use. So if you don't know about it, there's at least an argument that, if you just found out about it and it's been happening for 3 years, you're in different markets, then yes, you can still enforce it. And also, trademark law is a little bit reasonable that while we hope that people are enforcing trademark rights, we realize you have, you know, buildings to keep up, employees to keep employed. You know, the sole purpose of your business is not to, you know, enforce trademarks, and I wouldn't want it to be. So there is a little bit of, you know, forgiveness that, you know, as long as you're doing some things to protect your trademark, you know, if you don't do every single, you know, use that's out there, because that can be an endless crusade, then that would be sufficient enforcement of your trademark.
My other question was about, you're talking about trademarking pieces. Are you suggesting that individual beer names for every beer you make, should those be trademarked? Only if you intend to start shipping it outside the state, you know, go out nationally maybe? Or just, is that a good practice to try and do?
Sure. I think that would be on kind of an individual basis and kind of depend on, you know, how important that brand is to you. If it's a, you know, flagship, it was your first beer, it's the one you always have, then I would maybe lean towards it. If it's something you use seasonally or might, you know, you're not sure if you'll be using it in a couple of years, then it might not make sense, but that's certainly something, you know, that can vary, and we'd be happy to talk through.
Can we talk a little bit about like protection and then being on the other side of protection if you're accidentally or purposefully infringing on somebody's IP? We've read about it. I've heard it from too many people that I'd like, but I'm going to make this beer that looks really close to this thing so that I get a cease and desist and get a little press out of it. Can you tell me first on the protector side, like real high level, what are the steps that Miller takes when I make Miller Rye Life?
Sure.
And then from my side, if I make that beer, what do I see? And then, you know, what are my actions?
Sure. So in that situation, if you were the company A, they usually have services to monitor publications from the trademark office. So they're kind of getting a list and somebody's going through it, combing for things that might be similar. A lot of companies also have things like Google Alerts set up, you know, varying levels of sophistication. Google Alerts can be really efficient if, you know, you're kind of not as large of an operation, but still want to kind of keep an eye out for other things. So usually it's alerts, or, you know, given the industry and that people know each other, a lot of times it actually is through word of mouth that people can hear things as well. So that's how someone who has a trademark that might, you know, be worrying about a potential infringement usually would find out about it. So I think that was the first part of your question. And then the second part was, if you're the adopter and you're coming up with this new mark and you're like, well, it's kind of similar, but it's a little bit different, kind of how to assess that, or how?
Just more like, okay, so I'm protecting a mark. Mm-hmm. What are the steps that I take? I send a letter, right? An angry letter that says, stop it, right? They don't stop it, then what happens?
So send the letter. It depends on whether or not they have a trademark filing. If they have a trademark filing, there's a lot of leverage you can get out of opposing that, that we usually recommend. And then there are other options like injunctions and things that, you know, are further down the road. Usually we see people, depending on the size, that the cost of defending is not worth it. So usually there's kind of a space in between, you know. There's often several rounds going back and forth of cease and desist letters. There might be a phase out period. There might be like a back licensing fee, different things like that to, you know, not go quite from 0 to 120, you know, full-fledged litigation.
Okay. And in your experience, are there certain companies that go to 120 right away? Or is it typically like the slow burn, send the cease and desist, see what the reaction is? Or are there a lot of companies that just put the hammer down?
In my experience, it's more of kind of the slow burn. People do want to try and be reasonable because they have to expend money too. If they're going to go 120, they have to have the fee, the money to do so. Some bigger companies that do have resources and have whole legal departments dedicated to kind of monitoring infringement might be a little more speedy on that. But that would probably definitely be part of the trademark analysis. That's something I always look for. When we're looking at other companies, are we looking at similar size? Are we looking at, larger companies? And if so, do they have a history of kind of going 120? Do we have, case filings and, different proceedings that they immediately file? And that's not too difficult from a legal side to kind of research and kind of help at least identify those risks where we might have somebody who might go, pedal to the metal right away.
Thanks.
You're welcome. Yes.
If you're doing trademark research and you see that there's a, say, very classic name that has now no longer being used by a corporation, but it's very distinctive. So if you're using the Miller High Life, the champagne of beers, and if Miller decides to no longer use that, could any of us take that? And then, could Miller still come after you saying, I know we're not using that trademark anymore, but people do identify champagne of beers with us, so don't use it?
Yeah, that is a good question. So with trademarks, it's kind of you use it or you lose it deal. So they would no longer have a trademark case if they completely stopped using it and never going to use it again. There is also in the Trademark Act there are some other causes of action, including unfair competition or false association. So those ones can be a little bit harder to prove, but I think if you did champagne of beers and did other things to enhance the association, there might still be causes of action. That's actually an area of law that's still kind of being decided. If you purposely abandon the mark, on one hand, you're no longer investing in it. So, what's your right to, stop other people from using what you have purposely abandoned? And actually, we're kind of still seeing that one play out. Yeah. Yes.
So, if you have your trademarked name for your business or whatever your product, does that stop other people from buying up all the domains that have anything to do with it? Is there anything you can do? Or I know, my husband's business, they buy up all the domains that have any word that has anything to do with their business. But if somebody has that,
sure,
can they get in trouble for that?
Yeah. So the question was a really great one. If you have the trademark, can you prohibit other people from registering domain names with that trademark in it? The long and short of it is you can register pretty much anything you want to register. So a lot of companies do take that approach where they register a lot of domain names, particularly because most start around $5 to $20 a year, and so it's cheaper to do that. If you do have a trademark registration, you do have the right to tell them, hey, stop it. There are, a lot of domain name registrars have kind of mechanisms where you can report the domain name, and there's also administrative proceedings, which is kind of where you submit a complaint. So it's not as scary as court, and it's way smaller, but there are mechanisms kind of in place for that exact sort of thing. Great. All right. Did we have any other questions? I'm also happy to talk afterwards or... Excellent. Well, thank you so much for your time this evening. I really appreciate you coming here. Hope you learned something and that you enjoyed our IPA, or at least got something out of it. And thank you so much for helping me film my first episode of my new podcast. So thank you.